We have 4 requests for adjournment. 2779 Cowles Associates, 477 Little Plains Road. 2782 1280. And 2783 James Branca, 248 White Street. And 2784 Gerald Rose Garden, 15 Pelham Street and 148 Moses Lane. Can I have a motion to adjourn all those?
I move the adjourn all those there.
Do we have a second?
cases.
I'll second.
All in favor?
Aye.
Okay. And we have one decision, 2777 45 Moses Lane LLC, 45 Moses Lane. I don't know why it says Main Lane.
I move we accept this decision as proposed.
I'll second it.
All in favor?
Aye.
Kevin, here's one for the file.
All right,
You know, I didn't send it to the village office because
okay.
we didn't have a quorum at the work session. But you can put that in the file.
You
and
got a stamp on it, Kevin?
I'll try to remember to have my secretary email one to the zoning board office tomorrow so that they'll have an email version also.
Here's a stamp for it.
Stamp it, lad. If you're getting a big
Oh,
vote.
oh, oh, that's right. You're right, you're right, you're right. Good thing you reminded me.
Jim or somebody. Not me.
All right.
How's that?
Pretty assertive.
I don't know, I can't see it.
I guess we have nothing on 2746, 550, and 554 Hill Street. That's still before the planning board, right?
Yes.
So we should just adjourn
Adjourn
that
that,
again.
yeah.
Can I have a motion on that one?
I move we adjourn case number 2746.
Second. You have a second?
Yeah, second.
All in favor?
Aye.
And we have one carryover case, which is 2781 Barbara Lowy, 75 First Nick Lane.
Good evening. Kevin McGowan of Essex Scepter and Angel for the applicants John and Barbara Lowy. We submitted a response to the board's 2 questions from the last hearing. Came in yesterday. I'm not sure if you all had a chance to review it, but responded to the 2 questions. That was 1, the proper classification of the driveway / right-of-way that goes to the Taylor property behind this parcel. And the second was the composition of the driveway on the site. I'll just address the second issue quickly, as I think that's the more straightforward. The question was asked of what the driveway was composed of and whether it was pervious. And it's a stone on oil driveway, so it's not pervious. However, there is an existing drain and dry well that's shown on the survey to the south of the driveway that as the letter from Frank Lappy, the contractor for the site, said is sufficient to handle all the rain and stormwater runoff for the driveway, including from the existing carport, which this application proposes a garage instead of the carport there, so there wouldn't be much change. But in the event the board still wanted additional measures put in place, the clients would be willing to put an additional drain and dry well under the gutter of the proposed garage to ensure that there's no issues with runoff. If there aren't any other questions on that matter, the other issue was with regard to the driveway on the southern lot line. And in that regard, the issue was that our application is requesting a side yard waiver for the garage, which has a 27-foot setback from that southern lot line. So it's really only a 3-foot variance in that instance. However, if that driveway is a private road, it would be a corner lot, and that would be a front yard. So it wouldn't change the nature of the request, except that it would be a larger variance request. It would be 80-foot front yard setback would apply. We submitted a letter, a determination letter from Ken Hosso, the building inspector, speaking to their opinion that the driveway is, in fact, nothing more than a driveway and part of a flag lot, and that the side lot line setback should apply. And then we also submitted a revised survey that changed the description of the Taylor driveway to a right-of-way instead of a private road. And finally, we submitted the survey associated with the Taylor property, which was recently before the board in association with a variance for a tennis court. And that referred to that same piece as a driveway and not a right-of-way or a private road. My understanding is that Mr. DePietris still has an existing question as to the proper classification of that strip. The idea that being that regardless of whether it's a right-of-way or a private road, it still may legally function as a road and require the front
That's not
yard
Quite
setback.
an accurate description, but.
I apologize. I don't mean to. I'm just paraphrasing. But that being said, my understanding is further research was requested into this matter, which might entail engaging a title company to go back in history and definitively determine.
You may, yeah, okay. You may not need that. I don't know if you had a chance to talk to the surveyor today.
I spoke with Lester Holden
but
today.
this-
He couldn't definitively determine from his records what that driveway / right-of-way should be labeled as. He has right-of-way on there now. He didn't have any specific rationale for that other than he did have a pass file that referred to it that way, but it was inconsistent in his office, as evidenced by the same office referred to that as the driveway in the
The
Taylor.
survey does not show it as a right-of-way.
Right, and it's the same office, which
So
So there's some inconsistency within the office, but because he knows that this is a matter before your board and it's a specific issue that's been raised, he's reluctant to change the description to a driveway or remove the description altogether without further research. And he indicated that that research he wasn't confident could be done through his office, but rather should be done through a title company. All that being said, it would be an additional expense, but we'd be willing to perform the additional research if the board deems it necessary to do so.
Kind of sounds like you have no choice, right?
it should be done. I don't have any, there's very little doubt in my mind that that is probably not a right-of-way. There's no indication, well, whatever. But without any, with the survey showing it as a right-of-way, that means that the surveyor thinks that somebody has a right-of-way over it. Could be one or more other parcels. If the Taylor property is the only property that has the right to use it, Taylor owns that strip of land. It's part of his lot, so it wouldn't be called a right-of-way. So when the surveyor labels it a right-of-way, that raises a question. If the survey didn't label it a right-of-way, I wouldn't even be raising the issue. But we, in the face of a survey that labels it a right-of-way, because it doesn't just affect this property, it affects other properties.
That's right.
So, my recommendation is that we should find out whether any parcel has a right to use that strip of land.
Probably be advantageous to your client to have it cleaned up anyway.
Okay. I would just want to make the point that
Even if somebody does have the right, that does, I don't want anybody to misunderstand me. That doesn't necessarily mean that it's a private road, but we'd have to know what parcels have an easement over that strip of land. That's what a right-of-way is, an easement.
I'd just like to point out, we will look into this matter, but as it affects this parcel, in the alternative, if we did request a front yard waiver, we still think that this case warrants approval under the front yard request. Obviously, we'd prefer to do it as a side yard with just the 3-foot encroachment into the side yard setback, but the same arguments would apply regarding the character to the neighborhood. It would be the exact same application. The front yard at issue would be a road that, for all intents and purposes, functions solely as a driveway for the Taylor property. It doesn't go further than that, regardless of its legal status. So just in that sense, it's somewhat academic as it applies to this parcel, because we believe regardless of what the actual designation of that driveway / right-of-way is, that this case has merit.
Is there anybody else here on this application? No, as far as I'm concerned, we can, I mean, this is just a pure legal issue that will depend on what he submits by way of written material showing whether one or more parcels have the right to use that. So as far as I'm concerned, we can close the matter for decision subject to receipt of title information clarifying the right-of-way issue. And then everybody doesn't have to come back.
Do we have people out in the audience that'd like to refer to this application? No, we already asked that once already.
Okay.
So what you want us to do is to hold this for decision
I'm saying we could do that if
pending.
right, we couldn't render a decision until he gets me the information.
Right,
Right.
But if he gets me the information and it shows what I suspect it will show,
and we can have a decision.
it will eliminate the issue.
We're amenable to that. In the
See,
off
there are
chance,
inconsistent surveys. The Taylor survey doesn't show it as a right-of-way. The Lowy survey shows it as a right-of-way. One of them is wrong.
right, and I would just say in the off chance that it doesn't show what we expect it to, we would like to reserve or have some guidance as to whether the case can be considered as a front yard variance as it is, or whether you want us to, whether it would be reopened and we could submit a brief rundown of how it satisfies the criteria in that
If
case.
the information you submit doesn't eliminate the right-of-way issue, then we'll have to reopen it.
Right.
Okay.
Okay.
I move we close this case for decision pending requested information.
All second?
All in favor?
Aye.
Thank you for your consideration. Is there a specific submission date?
Submission date.
You can get it, all you have to do is, you can get it to me. If you send a copy to me directly, when you send one to the zoning board with a copy directly to me at my office, and then I'll look at it
Okay.
when it comes in.
Thank you. Good night.
That brings us down to the new cases. First one being 2785 Chester's House LLC, 288 Halsey Neck Lane.
The applicant, John David Rose, architect. The attorney is not here yet. I would ask that perhaps we could push this to the bottom of the agenda and hear the next case.
That's okay, but there's only one more case.
The bottom's pretty close.
You're pretty close to the bottom now.
I understand that. I'm hoping she'll be here any minute now.
All right, we can go on to the next case,
Thank you.
which is,
Timing is everything.
oh, she's here, okay.
I
So we can keep you
Up and
there.
down.
You're last, she's last.
Last?
Well, you
Okay,
decided to
that's
give up your
You want to be
slot.
last? Okay, all right.
I was trying to find.
Pushes you way back till about 11:30 or so, is that okay? It takes us up to 2786, 354 South Main Street.
Good evening, I'm Linda Riley, 235 Hampton Road for the applicant, which is 354 South Main Street LLC. I have an affidavit of posting and mailing to hand up. I also have some supplemental material to hand up. I have a packet for everybody, I think. Or shall I pass them down to you? Yeah, okay. Here, you can pass them down. Right on top, did you have enough? Shall I hand up another one?
He's still handing them out.
Oh, I see. Have to go by the, there we go. Right on top of the materials I just handed up is a new survey. It's really the same survey that was submitted with the application with
Yes.
with one amendment that has actually nothing to do with the relief that we're seeking, but I wanted to make sure that everything on the survey matches everything on the plans and elevations, and there was one sort of disconnect. The only change that was made on this survey that is on top of your packet is with respect to gross floor area. The calculations are slightly different because they did the architect did the refined calculations with his computer, and they came up a little different than Squires had them. So Squires put the architect's calculations for gross floor area on here. Otherwise, everything is the same, the coverage and the setbacks and everything else, everything except the gross floor area. And actually, we're not seeking a variance for gross floor area in any event. We're seeking really only relief from one provision of the code, which is a rear yard variance. We're seeking a rear yard variance in two different locations, really. And for this, if you turn to the third page, the aerial, perhaps it's easiest to see, and I can point it out here. There's going to be, the application is for a new addition that would come out toward the side here, in the back, in the rear, along here where I'm pointing. And also for a tiny little 45 square foot addition to the Four Seasons room, or the little greenhouse room that you see on the survey with the little mark on it right here, proposed addition. It's a tiny little 45 square foot sort of evening out of that existing structure. Both of these things, the two-story addition that you see on the plan and the evening out of the greenhouse, are both at the existing setback for the house. The house is at a 40.1 foot setback, and both of these additions respect that existing setback, which is, in fact, nonconforming. The nonconforming setback of 40.1 was created decades ago when the lot was subdivided. It had previously been one lot with 3 houses on it, and this was subdivided, and that's what created that 40.1 foot setback that exists there now. The request is really necessitated by the fact that this house is landmarked. I have a picture in your packet of the house. I'm sure it's called Windicott, and I'm sure you're all familiar with it. And when you look at the picture, you can remember which one it is. It's got a very, very distinctive front facade. It is landmarked. And there is nothing that the owners really can do, or want to do for that matter, with respect to the front of the facade or any of the important architectural features. Those, must be preserved and will be preserved. In fact, a lot of the difficulty that we face here comes from the fact that the whole front of the house and the sides do have to be preserved. The house is set back 126 feet, more than 126 feet, from the front boundary line, which is far in excess of the 80 feet that is required. And as a result, much of their building envelope is unusable. We have the building envelope for principal structures depicted on the survey that is on the front of the packet I just handed up. And you can see that dashed line really runs through the middle of the existing 2.5-story house. Everything in the front of that dashed line must be preserved because of the landmark status. The couple who bought the house have one child and another one on the way. They're expecting another child. They also have a grandmother arriving who's going to be living with them. And there is no garage on the premises. So what they seek to do is to add a 3-bay garage, which is going to take up essentially the entire first floor of this 2-story addition. So at this point, I also want to point out that if it were only the garage they were adding, a 1-story garage in that location, it would be permitted as a matter of right, because it is within the accessory setback requirements. But the fact is, they are going to connect it to the house, and on the second floor, they are seeking some bedrooms and a sitting area for, essentially for staff, possibly for the grandmother. Basically, we're talking about help for childcare. But the second floor will be connected to the first floor. It will be all connected on the second floor. On the first floor, there's going to be an open breezeway between the house and the garage, but the second floor will be connected straight through. There is one other technical variance that's required here, and that is, you will see on the surveys that I handed up on the front of your packet again, that just to the, let's see, what is that? Just to the west of the breezeway addition, there is a little dotted line where it's part of the existing roof. There's a little covered porch off the kitchen, which is not an original architectural feature. It's just kind of an add-on there. And part of their proposal is to fill in the covered porch. They're not adding any floor area there. They're not expanding the footprint, but the porch will be enclosed and included within the kitchen area. So even though that's in front of the addition that we're proposing to add, because it is within the required rear yard setback, it was the building inspector's determination that we needed a variance there too. So this application also covers that. Now, there are a number of improvements that they're making here that, in conjunction with this renovation, that are going to be, I think, very beneficial to the setting of the house, the neighbors, and the community as large. For one thing, they're removing the tennis court altogether. The tennis court that's there now brings the lot coverage up over, the existing lot coverage, up over what would ordinarily be permitted. And they are going to take out the tennis court with the result that the lot coverage, which again now exceeds the allowable 10,592 square feet, will be greatly reduced to only 7,224 feet. When they remove the tennis court, they are also going to relocate the pool, which is now at about a 50-foot setback from the rear property line. It's in the rear. That'll be moved to where the tennis court is now. So the same neighbor to the rear who is affected or might be affected by this addition, or and the small addition, is also going to benefit from the elimination of the tennis court altogether and from the relocation of the pool further away from them. I included the aerial shot in your packet because the purpose of that was to demonstrate, here's the tennis court that's going to be removed. Here's where the new wing will be. On the aerial, you can see it's going to be back here. What's on the other side of that property line from the addition is the neighboring property owner's pool house. That structure that you see is a pool house. That property takes access off of Gin Lane. Its address is 45 Gin Lane. There's a house in back you can see. The pool house is really the only thing that's going to be at all close to the addition. And in fact, the pool house has a setback of 20 feet. I included their survey so at the back of this packet so that you could see where I got that figure from, about the pool house on the neighbor's lot. This pool house will completely screen from the neighbor's backyard or their functional backyard. It'll completely stand in front of where this addition is going. It won't be able to see or experience the addition, I don't believe, given the location of the pool house. In back of their pool house, between the pool house and the rear lot line on their property, are all the mechanicals. They have, air conditioning, pool equipment, all kinds of mechanicals back there. So it's not an area that they use at all. And I think it's also useful to note on the aerial that you have that the neighbors have what looks like a lovely garden area here that's adjacent to my client's existing pool and tennis court close to the rear yard line, and both of those are going to be moved away. So it's sort of trading off, that's being moved away, and an addition is being put over here, like behind a pool house. I've already pointed out that the garage addition in itself could be added as a matter of right, but I have to address the living space on the second floor. I want to point out that the second floor is low. The peak of the roof at its highest will only be 25.6 feet, which is lower than the existing house, significantly lower than the existing house, and significantly lower than the code would allow height-wise. And also, there are only 3 windows up there on the second floor, and they're tucked-in dormers. It's a gable roof, very simple gable roof with 1 dormer off the back, 3 windows, and really that's the extent of it. So the impact of this second floor is really minimized from the rear property line where we are seeking the variance relief. Of course, this addition is going to be twice the distance from the rear yard line that their pool house is, twice as far. I submitted with my application a lengthy rider, I think, that went through each one of the criteria that you have to consider, the benefit to the neighborhood, or the lack of detriment, or the fact that there won't be any detriment to the neighborhood or the community, and the other elements. I always hate to get up and repeat the same thing that's in my application anyway. So I can do that if you would like me to, or I can simply take questions. I also want to let you know that the architect is here, John David Rose. He's got CAD drawings, big drawings that show exactly what the design is and elevations. If you'd like to have us bring those out at this time and show you any of the architectural features or exactly what's planned here or proposed. Of course, it's going to DRB for architectural review.
Why is the pool equipment so far away from our pool?
Now, I don't know. That was located by the former owners. My clients didn't make that decision.
But you're not going to change it with the new pool?
I think the new pool equipment is, but it will be changed, yeah.
Just not shown, I don't believe.
I can let the architect address that.
As long as it's in a conforming location.
There's a ton of, everything's conforming around it. So.
For the applicant, John David Rose, architect. Currently, as you can see on your survey where it's located, it will be put in a conforming location. One of the options we've done in the past that the village likes is to put it in the crawl space. That way we have no noise. The crawl space of the pool house. So they've allowed us to do that in the past. But there are many places in there that is a conforming location. As we develop the landscape architectural plans, you could be sure it'll be in a conforming location.
Just crawl space is crappy to work on.
Very crappy.
You could sink it,
He doesn't like to.
A retaining
recess
wall.
it on the outside rather than,
That's a great idea.
Yeah.
Yeah.
Tell them to get most of the pump noise anyway. Once you're down 2 feet and then you're,
Would you like to see the architecturals, or you won't insult me if you don't want to at this point?
I don't need to see it.
No, that's fine.
No.
Any other questions, though?
Do we have any questions? Rick, you got any?
Just have couple of things that we'll need to document. And this relates to the 50% limitation in the variance section. At the moment, I'm making an assumption that what you're showing as the existing floor area was all there at the time of the when was the variance to divide the property?
The variance was, I have it with me.
1989, I believe.
1989, that's right. It was 1989. I have it with me. And it was all there in 1989. I think I even have a copy of the survey with me.
Okay,
The
I'd
house-
like to see a copy of the 1989 variance decision
I have that with me.
and the subdivision map or whatever map was utilized to show the variance,
Yep.
just so we can confirm that the base for your 50% is what you're showing here as existing.
Right.
'Cause obviously, you're far less than the 50%.
Yes, far less. And the existing and the proposed is shown on the survey that you have, which was updated.
Yeah, all the data's on
Yeah.
here.
Yep.
If one assumes that what is existing is your base under the 50% clause.
Here is the decision from the 1989 variance. The building department was not able to give me the survey in one piece, but the critical part of it is in one piece.
Okay.
And you can see that even,
Is that
This
your
is
only
it?
copy or an extra copy?
this is my only copy, but I don't mind giving it to you, because I can get another one.
Okay.
You can see even, this greenhouse thing back here, the 40, you can, I got that from the building department files.
Okay. It looks like that, looks like the same basic house.
It hasn't been enlarged at all.
Okay, that satisfies me on that.
That's it?
That answers my question.
Okay, I wasn't sure if you had any other questions.
We have anyone out in the public who'd like to be heard of this application? No. You want to hold this for decision?
Yeah, because I do want to look at the variance decision that was handed up, et cetera. So we can close it for decision.
I move we close this case for decision.
One second.
All in favor?
Aye.
Brings us down to number 2785, Chester's House LLC, 288 Halsey Neck Lane.
Good evening, Mary Jane Assato, Burke Flanagan Assato, 21 South Main Street for the applicant. My apologies for being late. I sort of lost track that it's August, and I was driving up and down Third Street for a parking spot, and finally decided my office was the closest parking spot there was going to be. The application before you tonight is for an addition on the northerly side, a small addition, so we need for which we need a rear yard variance to 13 feet, and a proposed southerly addition for which a rear yard variance to 22.5 feet is required. And also, because this is substantially non-conforming condition, permission pursuant to 11628C1A to expand a pre-existing condition but not by more than 50% of the usable floor area. This property has the benefit of two previous variances. One of them was abandoned at the last recent decision, for which in 1997 there was variances granted to J.L. and Ornstein. And during that time, which my partner Gil Flanagan, in connection with his application, had submitted the decision, they had a previous issue in 2004 that was abandoned. But the variance is granted, and then the 2004 variance established the northerly addition, the pre-existing condition, and what we're adding now is less than the 50% as is set forth in the application. The existing floor area at the time was 3,610 feet. The proposed additions would add 410 square feet, 173 for the northerly addition, 237 for the southerly addition. It's an 11.3% increase in usable floor area, so still it's at 43.7, which is less than 50%. I just wanted to get that out of the way. If you look at the lot, it's long and narrow width-wise. It's substantially non-conforming in that it's a little bit over 40,000 square feet in a 120 residential zone. Moreover, all of the improvements are sort of at the southeast corner, so that technically there is no buildable area of right. The required front and rear yard sort of merge so that anything on this house pretty much needs a variance. If you look at the property, the one-story addition to the north, it's to add a bedroom and bathroom. The architect is here to speak to that. And then the further southerly expansion is to expand the kitchen. I submit to you that there is an existing terrace patio out there, outdoor living space. That is going to be abandoned. So in some respects, I know that when the board is considering a neighborhood impact, that patio area, which is outdoor dining, I mean, this is a summer community, versus that's going to all go away and replaced by an enclosed addition, which is actually on the side yard side conforming. On the rear yard, even though a variance is required because we have a non-conforming condition here all around, it is further away than the existing terrace and further away than the edge of the house. The north addition as well, it's no closer. In fact, it's sort of, because the property, the house is not set square to the property lines, it goes further away. We have a letter here, although Mr. Rose is here, from the architect, basically addressed to Gil, saying both the south kitchen addition and the northwest bedroom addition roofs will align with the existing flat roof portion of the house, and this is approximately 10.6 feet off of the existing grades. So we're talking about flat-roofed, low additions. I'd like to submit that so that you can each see that from Mr. Rose's office. So let me see you. Do you want to? So we're not talking about roof lines that are going to be excessively high. Additionally, and I'm just going to give you, and if you would pass it around, we have photographs that show that view of the location for the northeast addition, one story looking southeast. You'll see there is a massive hedge. And then there is also a picture of the south property line, approximate location of the kitchen, one-story addition looking southeast. Again, there's a very, very substantial hedge. 1, 2, 3, 4, 5. If you can just, after you stand it around, and I'll give Rick his. Last but not least, just wanted to, my partner went to the building department and obtained surveys of the existing condition, the latest of the most impacted properties. This is subject property up in the corner. and I'm going to give you this is the subject property that we're talking about. I'm talking, this is a survey. As you can see, basically here, we have a situation where that this is sort of hard to tell here, but we are not, we're at least 20-some feet away. It's not like we're right up adjacent to this property. The other property that's impacted has a very irregular shape, and I would submit that they're not impacted at all. It's in pieces. It's that property that has like sort of a flag with a flagpole connects the two pieces. Well, this is us, and it's 165 feet away from where their house is. We scaled it. This is a 1:40 scale, and here's their swimming pool, and then we still have room here. So it's not like we're sitting on top of either house. We're not getting any closer. In fact, we're further away in one respect for the kitchen addition than the edge of the house and where the terrace patio, which is going away. And for the northwesterly bedroom bath addition, it's flares away, and it's no closer than, in fact, we would say that it is further away than the closest part of the house. As we indicated to you, there's no way that this house can be expanded without a benefit of the variance. We submit to you that when you weigh and balance the hardship and the practical difficulties with the detriment, we have an existing house. None of the proposed additions any closer than existing, where the house existing, the extreme edges are. And I think it's relevant that this outdoor patio area, which people live on during the summer, is going away entirely for a small enclosed kitchen addition, which is further away substantially than the edge of the patio. If the board has questions to the architect or myself.
I have a question. You briefly went over previous variances.
Yes.
And one was 94, which was relinquished. It's no longer in effect?
Yeah. Previous owners of the premises, Richard and Christine Toppins, obtained certain variants of the Board of Appeals to expand the existing residence by decision dated March 25th, 2004. And that
was
copy,
never performed, and the variance...
parts of it was because the proposed garage down here has the benefit of the variance, and that's going to be constructed at this time in connection with, if you should, approve this construction. That was not abandoned. What I'm saying is, such decision involved other things, the relinquishment of a prior 1997 variance. So they got a variance in 2004, but in connection with that, they gave up the 1997 variance.
Okay.
And then the 2004 variance is where the pre-existing 50% floor areas were established, and I was reading out those things to you that where I'm getting those numbers that we don't go past the 50% is the numbers that were from the 2004 variance.
Because there was a 2004 variance, but it wasn't built, but you're going to build that now.
The garage portion of it
Right.
wasn't built, yes,
Right.
yeah.
I'm a little fuzzy about what the other parts of that variance...
There was expansions on that variances as well.
But other than the garage, there are not going to be...
All the others were already done.
So everything was completed except the garage from that
Yes.
2004?
2004 variance.
Okay. So you're just, by doing the garage, you're basically finishing out the 2000?
Yes.
Okay. So there's nothing, after this work is done, hanging out there?
No.
Okay.
So the 1997 variance was abandoned in its entirety. They gave it up when they came up to 2004. The 2004 variance involved expansions to the house, and that's why they had to establish the base for the 50%. They did all the house things. They didn't do the garage. The garage is going to be done now. It closes that out. And these two little additions, and we're still below the 50% for usable floor area.
Do we have a copy of that decision?
Yes, it's all been submitted with your packet, the 2004. You know Gil, he wouldn't have left that out.
That's it. That was my question.
Rick, do you have anything?
I just had one question. This pieced together large survey that you handed up, that's a survey of which property?
Oh, sorry. I'll.
The property to
Tax map that one.
property to the east
Yeah.
that
he's-
adjoins this?
Hold on. We marked it on the tax map. I'm gonna get, it's this property here. So that irregular shaped one is the,
If you haven't given us the tax map, you're pointing something out, it's not gonna tell me anything.
sorry, hold on.
Where is it on your survey?
I will tell you. This is tax map number. It's pieced together, so I'm looking for, oh, here it is. 904-1447. So, that is the, 904-1447. That is the property to the right of mine, so this large piece is 2097, which means it is to the, where's the directional on there? Here, let me show you. This is us, and it's the one right next door to the right.
Be to the south, you know?
South, yeah, it would be the south,
That's a new house they just finished building?
Okay, well, what's to the east?
I think so.
Pretty new, yeah.
the,
A lot of work going on down there.
this is us.
Drive with you.
And it's this property point, the tax map number, if you look at the Nathan Taft Corwin survey, it says here it's for tax 904-1447. So that would be here to the south. And then to the rear yard, I'm giving you this piece here, this irregularly shaped one, and that's the one that was tax map number 904-14405.
I guess I don't have that one. Did you say you handed it up?
I gave this one here. The one that has the one that was 165 feet, maybe I didn't give you a copy when I handed up here.
I only got one. Maybe
Okay,
I
here,
should-
there it is. That's the relevant portion, and that, it's connected by that long sort of linear flag
This
thing
is
with
the
the...
parcel to the east.
That is the parcel south, yes, that is the parcel to the east.
Okay.
Where it's, the house is 100 and some plus, I think 65
165 feet.
plus. Okay. There's an intervening pool somewhere in the middle there, but they're pretty far away.
That's all I had.
And the public would like to be heard of this application. No, we do not. Therefore, call for decision, are we ready for that?
No, I'm gonna have to, you're gonna adjourn it for decision. I
Well, that's what I mean. You want-
gotta juxtapose these things up against this and figure out what
We
she
can
submitted.
adjourn it for decision then.
You can adjourn it for decision, yes.
I move we adjourn for decision.
I'll second it.
All in favor?
Aye.
Thank you. Sorry, I couldn't get it in one.
No, I know, that's why I was asking you, so I could make a
I'm
note.
gonna do it right now, yeah.
Move off the
And
camera.
that closes the August 22nd, 2013 meeting of the Southampton Village Zoning Board of Appeals.
See?